Welcome, sir. We will be starting in a while.
All right, all right. Take your time.
Good evening and a very heartfelt welcome to one and all present here. We are all we are all here for a distinguished lecture by Professor Ahmad Naseem, Dean of Law, Dean Dayal Upadhyay, Gorakhpur University. This lecture, titled Environmental Consequences of War, is part of the Knowledge Forum being conducted under the banner of Virtuosity Lexicon 2025, organized by Virtuosity Legal and ODR Nexus. Wars leave behind far more than visible ruins. Their consequences extend well beyond the immediate loss of human life and the destruction of cities and institutions. These environmental wounds linger long after ceasefires are declared, silently shaping the health, livelihoods, and futures of affected communities. This lecture seeks to explore these overlooked dimensions of warfare. We have with us Professor Ahmad Naseem. He is a distinguished academician currently serving as professor and head and Dean Faculty of Law with over 25 years of teaching experience. His key areas of specialization include environmental law, Muslim law, and Hindu law. It is our pleasure that he is also an AMU alumnus. Uh, Towards the end of the lecture, we'll have a brief question answer sessions, and all attendees are requested to drop their questions in the chat box. I welcome Professor M. Naseem. The floor is all yours. Sir, over to you.
Thank you, Nasha. Thank you very much. Am I audible?
Yes, sir, you're audible.
Actually, on my side, there is some technical problem. And continuously, the Zoom is sending me the message that it is not responding. So, should I leave the meeting and then again join?
So it must be a
What?
problem with your laptop. You may do that,
No,
sir.
I'm
We'll
not
find.
using my laptop right now. I'm using my mobile because there are some issues with my laptop also. But anyway, don't worry. Don't worry if you can hear me. And if you are
You are
getting my
audible to
video, there is
us.
no problem. There is no problem. All right. Thank you. I could not hear right in the beginning what you said, but I guess uh, all of you want to listen to something. Okay. Thank you. Thank you very much for giving me this opportunity. Your organization is known as Virtuosity Legal, isn't it? Okay. So, how many of you are from Aligarh? All of you or some of you?
So in the lecture, some of us.
Some of you. All right. All right. Doesn't matter. Doesn't matter. We belong to the legal fraternity in any case. I I am an Ali. I did my LLB 3 years from Aligarh. I did my LLM also from there. In fact, before doing LLB, I had graduated. It is National continuously. It is sending me the message that it is not responding. Please allow me to leave the meeting and join again.
Yes, sir. Yes, sir. Sure.
Okay, please don't mind. Okay, all right. So, am I audible now?
Yes,
Hello.
sir, you are.
All right, all right. So I was giving my introduction. I had done LLB, and before doing LLB, I did my BSc from Aligarh, and finally I did LLM in 1996. That was that no not in 1996. That was the year 1997. And since 1998, I'm working in Deen Dayal Upadhyay Gorakhpur University. Initially, I joined as a lecturer at that time. Presently, I'm a professor. I'm ex-dean. I'm not dean right now. I'm ex-dean. So, young boys and girls, uh, today we are going to talk about environmental consequences of law. Uh, when initially I got this message by Mahvish, uh, who happens to be the daughter of my senior, uh, Khalid Bhai, who is a professor in Shibli National College, Azamgarh. He was my senior, and we had very good relationship. Still, we enjoy that relationship. He's a guide and mentor for me. So Mavish sent me a message that she wants me to speak on environmental consequences of law. All right. So I'm here. I'm a student of environmental law and family law. Family law is my first law, but environmental law is also one area which I have been teaching for the last 20 years in Gorakhpur University. And probably my batch at Aligarh was the first batch which was taught environmental law. In those days, we did not have much of material to study, and there was one book uh, written by Armin Rosenkranz. It is a very good book. I have the latest edition, but it was the only book at that time. There was some material written by Professor P. Leela Krishnan also. Uh, Professor Leela Krishnan, he was also an Allegorian, and he had worked in the field of environmental law. He had collected material, and he has uh, summed up beautifully. Still, there are some many editions of his books, and that also helped us. Anyway, the topic today is environmental consequences of war. When I started thinking what to speak on it, I thought all of you are the students of law, and you want me to hear about the legal aspect of the consequences of war, particularly the environmental consequences. I guess I don't need to explain the consequences of war. It is summed up beautifully in principle number principle number 24 Rio Declaration in a very short sentence. It says warfare is inherently destructive of sustainable development. Inherently destructive. Undoubtedly. Every sane person knows this fact that the first victim of war or any armed conflict, be it international or within a nation, within a country, internal armed conflict or international armed conflict, the first silent victim is environment. It does not take its revenge immediately, but gradually as the time passes, we realize the consequences and we feel and we pay. We face the music of what we have done. So, if we look at Rio Declaration, this principle says clearly, and before Rio Declaration, in Stockholm Declaration 1972, principle number 26 said that mankind and his environment must be spared the effects of nuclear weapons and all other means of mass destruction. States must strive to reach prompt agreement in the relevant international organs on the elimination and complete destruction of such weapons. True. Needless to explain, these words are self-explanatory. I don't need to explain further. Now, as far as the examples are concerned, what consequences war has on environment, we have few glaring examples right in front of us, almost. As a matter of fact, these examples are not very old examples. During the Second World War, the atom bomb was dropped by US forces on Hiroshima and Nagasaki. During Vietnam War, vast, large-scale destruction was documented. During Gulf War between Iraq and Allied forces of USA, NATO forces, we witnessed massive destruction of environment. And recently, at present, we are witnessing in case of the war which is going on between Russia and Ukraine, Israel and Palestine. Now, here, one can say that what we are witnessing is the destruction of the cities. But my question is, do you think that only natural environment is part of environment? Don't you think man-made environment is equally significant? In my opinion, as far as my view is concerned, I feel that undoubtedly, when we start thinking about environment, we consider natural environment for the first time to begin with. But as we study further, we will realize that man-made environment is equally significant. We cannot survive without man-made environment. And if anybody has any doubt about this fact, my suggestion to that fellow is that please watch a very, very beautiful movie of Hollywood. The name of that movie is Cast Away. Cast Away. It's a beautiful movie. If you get this opportunity, you will find this movie even on YouTube and you may watch it. Then you will realize how important man made environment is. So, not only the natural environment, but even the man made environment is extremely significant for us. We cannot survive without the cities, the kind of cities, the infrastructure we are enjoying today, the kind of life we are leading today, the kind of machines which have become part of our life. We cannot even think of existing without those machines and without those equipments. So almost we have become slaves of the technology, the machines, the modern way of life, the modern vehicles, roads, infrastructure, human settlement, hospitals, colleges, universities. All these things are man made, and we cannot survive without these things. So, my submission, first submission is that if anybody has got any doubt about this fact, he must think about it. He must think twice. And as far as my opinion is concerned, you're not bound to follow my opinion. You're not bound to accept my opinion. But my request is that you must listen to what I am saying or anybody says in this regard. You must think over it. So, as far as my opinion is concerned, man-made is environment is equally significant. Now, taking both the components of environment, natural as well as environment together, let us discuss the subject. Now, when I'm addressing the issue or the protection issue of the protection of environment, in my opinion is that I'm considering both natural as well as man-made environment together. Now, as far as the law is concerned, what does the law say? And where do we find laws with regard to the protection of environment? All of us know that earlier, a few years back, about 100 years back, environment was not a matter of concern for humanity. We used to think, or our forefathers used to think, probably, that nature is so large hearted that it will tolerate all our actions and all the consequences of our actions. It is not going to take revenge. And probably humans at that time felt that our activities are not going to harm the nature. Nature is so big, so large hearted. But gradually, with the scientific advancement, industrialization, and rapid growth of cities and growth in population, we started realizing that no, our conception was wrong, and environment is nature, for that matter, is not that large-hearted. There is a limit of its tolerance or acceptance of our activities. So gradually, in the second half of the 20th century, the world community realized this fact and they started taking actions. They started meeting, taking decisions for the protection of environment. The global community realized to the fact that environment needs to be protected. Now, during the wartime, how to protect environment and what does the law say? Let us one by one try to figure out by by going through the various literature available uh, on the laws of war. The first thing is that under let us try to understand the protection of environment under customary international law of war. As far as the customary international law of war is concerned, we do not find any direct provision with regard to the protection of environment. There are certain principles. There are certain principles regarding war which help us in the protection, to some extent, help us in the protection of environment. The first fundamental customary rule is codified in the 1868 St. Petersburg Declaration on renouncing the use in times of war of explosives projectiles under 400-gram weight. The second fundamental principle is that the means and methods of warfare available to belligerents are not unlimited. I repeat, means and methods of warfare available to the belligerents are not unlimited. That means we cannot use all the means and methods of warfare if at all we want to engage in warfare. Further principle says that there has to be during the war we have to keep in mind some basic principles and balance has to be created. Keeping certain things in mind. Number one, proportionality, the principle of proportionality. One cannot use the force which is not proportional. The other principle is the principle of non-discrimination. We cannot discriminate during war. And the principle of not causing unnecessary suffering to the people. These are the basic, principles which we find in the customary international law of war. If we summarize these things, one can say that weapons and tactics resorted to must be reasonably necessary to achieve a military object. Weapons and tactics resorted to must be reasonably necessary to achieve a military objective. That means we cannot exceed this limit. We cannot use weapons and tactics which are far more destructive. We can use force only to the extent that our military objective is achieved. The second one is only that amount of force which is necessary to achieve the prompt submission of the enemy may be used. If enemy is neutralized, we can if we can use, lesser force, and by using lesser force, if we are able to neutralize the enemy, then that is enough. We cannot exceed the limit. So these principles have been guiding us ever since the customary international law of war started growing. So these principles are still significant, but how far they are going to help us in the modern warfare, the kind of warfare we are witnessing these days, the kind of destruction we have witnessed in Ukraine, the kind of destruction we are witnessing in Gaza. Are these principles helping us? We have to think about it. Now, where does the problem lie? The problem actually lies in the lack of an institutional framework for the implementation, enforcement of law of war. We don't have any institutional framework for the implementation at international level, and it's a serious lacuna. It's a serious lacuna. all the principles which we have under customary international law, they are very, I mean, a bundle of general principles, and they are only certain guidelines. Now, coming to the conventions which are available and which guide us during the war, and which are part of the international humanitarian law, we find certain principles over there with regard to the protection of environment. And in international conventions, some of the conventions which are significant from the point of view of our subject are 1907 Hague Convention, Fourth Hague Convention. The second one is 1949 Geneva Convention, Fourth Convention, relating to the civilian population. Then Additional Protocol 1, and there are some principles in Additional Protocol. We will discuss those principles. And ENMOD Convention. We will look into these conventions one by one. Now, let us try to understand what is given in 1907 Hague Convention. In Hague Convention, under Article 23G, it is said that it is especially forbidden to destroy or seize the enemy's property unless such destruction or seizure be imperatively demanded by the necessities of war. Now, if we analyze, we find that this article says that it is especially forbidden to destroy or seize the enemy's property. Forbidden. However, it can be done if the demand of the necessities of war requires. That means this provision can be violated. When the necessities of war so demand, the property can be seized, the property can be destroyed, and the property includes environment also. Why I'm saying so? Because for that you will have to read section 2A, where the definition of environment has been given under Environment Protection Act 1986. If you go through that definition, you will realize why I'm saying so. Because the way section 2A Environment Protection Act 1986 defines environment, property becomes part of environment. So if here, in certain situations, when the necessities of war demand, the destruction of property is allowed by Article 23G, it means that even environment can be destroyed. So the rule says that you cannot destroy. Exception says that when the necessities of war demand, you may destroy. Now, sometimes this exception overshadows the rule. And especially when all of us know that the commanders in the field are allowed to use a wide margin of discretion in determining the legality of their actions. In most of the cases, they may claim that the necessities of war demanded the seizure or destruction of the property, and therefore they destroyed it. If we look at Article 55 of the same convention, which is applicable during the context of belligerent occupation, it deems occupying states to be administrators and usufructuary of public forces and agricultural sites. This article deems occupying states to be administrators and usufructuary of public forest and agricultural sites. Now, the occupying power becomes the administrator and usufructuary, although it is required to deal with these things in good faith, but the occupier has control over it. In many cases, we find that the occupier may not function in good faith. although he is required to do so. Why I'm saying so? I'm saying this because in case of when the situation is of war, armed conflict, we witness, and there are a number of examples that the demand of law is not fulfilled. The law requires one thing and the actions explain something else. We witness the violations of laws uh, more during war, because during war the sentiments are very high. Generally, the negative sentiments are very high. Now, if we uh, d- discuss the provisions of 1949 Geneva Convention, Fourth Geneva Convention, here we find uh, Article 53. This Article 53 actually expands the protection of property contained in Article 55 of Hague Regulation, which I just read. Here, Article 53 says that any destruction of the occupying power of real or personal property belonging individually or collectively to private persons or to the state or to other public authorities or to social or cooperative organizations is prohibited, except where such destruction is rendered absolutely necessary by military operation. Except, now exception says that except where such destruction is rendered absolutely necessary by military operation. Now, here also we find there is exception. Initially, there is prohibition. The destruction is prohibited. However, however, in case of absolute necessity by the military operation, uh, violation is possible. The property may be destroyed belonging to individuals, individually or collectively, or private persons or of a state. It can be destroyed. If we look at Article 147 of the same convention, that means Fourth Geneva Convention 1949, it says that unjustified destruction and appropriation of property not justified by military necessity and carried out unlawfully and wantonly to be grave breach of convention, which with personal responsibility attached to it. So, Article 147, it says that unjustified destruction and appropriation of property cannot be justified. Fine. Article 53 admits a defense. Article 53 I just read out before Article 147. It admits a defense of military necessity. I highlighted also that in case of military necessity, absolute if it becomes absolutely necessary, the violation is possible. So, what we are witnessing so far is that, of course, protection has been desired by these provisions, but there are exceptions also, and these exceptions can be exploited, and they are exploited during warfare, during armed conflict. Uh, uh, there are some people who have been punished also. During Nuremberg war crimes trial after the end of World War II, 9 German civilians were, punished. They were charged with ruthless exploitation of uh, Polish forestry, including the wholesale cutting of Polish timber to an extent far in excess of what was necessary to preserve the timber resources of the country. So, we have seen the conviction also of some people for the violation of these provisions. Now, uh, the most significant provision, in my opinion, is to be found in the additional protocol first of the Geneva Convention. There are 2 articles, and these 2 articles need to be understood very carefully. Article 35, Clause 3, and Article 55. These 2 articles need to be understood. Article 35(3) stipulates, it says, it is prohibited to employ methods of warfare which are intended or may be expected to cause widespread, long term, and severe damage to the natural environment. Plain and simple. Plain and simple. It says it is prohibited to employ methods of warfare. So it controls the methods of warfare which are intended or which may be expected to cause widespread, long term, and severe damage to the natural environment. Now, these three words are very significant. We need to understand. These words have been used, the way these words have been used need to be understood. The word widespread, if the damage is widespread, long term, and severe, that means according to this provision, the prohibition prohibition applies when the damage is widespread and long term and severe. This is the meaning I draw. And most people, when I was reading some uh, research papers on this issue, at least I found two research papers where the authors had this opinion. They said that widespread, long term, and severe, the way it has been written, these three words are very significant, and all of them collectively should be understood, and they have a cumulative effect. Only widespread is not enough, only long term is not enough, and only severe is not enough. It is quite possible that in some cases, if the damage is widespread, if the damage is long term also, but if it is not severe, then it is not prohibited. Similarly, if it is widespread and severe, but it is not long term, then again it is not prohibited. And if it is long term and severe, but it is not widespread, again it is not prohibited. So it means for applying this principle, widespread, long term, as well as severe, these three parameters together need to be proved. Now, this is problematic. This is problematic. Now, if we look at uh, Article 55 of the same convention, in its first in its clause 1, it says that care shall be taken in warfare to protect the natural environment against widespread, long term, and severe damage. Similar language has been used. Care shall be taken in warfare to protect the natural environment against widespread, long term, and severe damage. This protection includes a prohibition of the use of methods or means of warfare which are intended or may be expected to cause such damage to the natural environment and thereby to prejudice the health or survival of the population. Now, this whole clause has got some problems. Number one, the number one that it says that undoubtedly it encompasses only one of a very serious nature. When the damage is of very serious nature, widespread, long term, and severe, it means the damage has got to be very serious. If it is not serious, it is not prohibited. The way it has been written, it includes, the term includes, and the word it includes might seem to suggest that this provision would prohibit more than what is explicitly mentioned in it. However, the way it has been written and the words which have been used in the end of this clause are such that this provision becomes essentially anthropocentric. Why I'm saying it? Why I'm saying that it is anthropocentric? Anthropocentric means it is human centric. Deep ecologists disagree with this proposition. They say that humans alone are not important. All of us have studied Rio Declaration. In its principle number 1, it says that human beings are at the center of concerns for sustainable development. If you remember, this is a human-centric approach. Deep ecologists disagree with this provision, this proposition. They say why humans are important, and why humans alone should be at the center of concerns for sustainable development, when humans were not in existence on this planet. Even then, this planet had environment, and someday, if humans become extinct on this planet, even then, if the planet exists, environment will remain, but without humans. So humans alone are not important. Every single element of environment is important. So all those uh, persons who are deep ecologists, they disagree with this proposition. They do not like this kind of language, which is essentially anthropocentric, which I said means human centric. This provision is human centric. When it says that this protection includes a prohibition of use of methods or means of warfare which are intended or may be expected to cause such damage to the natural environment and thereby to prejudice the health or survival of the population. Which population? Obviously, here we are talking about the population, human population. And the moment we start talking about human population, it means the whole paragraph is for the protection of human population. What about other animals? Why should we discuss environment only in relation to humans? There are still many areas on this planet. You may find many planets where humans don't exist, but environment exists. So how come we are we are drawing, we are drafting laws at international level for the protection of humans only and not the environment? This is the objection of deep ecologists. Now, clause second says that attacks against natural environment may be uh, uh, by way of reprisal are prohibited. Attacks against natural environment by way of reprisals are prohibited. This this language is also problematic. I highlight why it is problematic. It says attacks against the natural environment by way of reprisals are prohibited. It means the direct attack is prohibited. Only the direct attack is prohibited. If it is indirect, if the natural environment is not targeted, then that means collateral damage can be done to natural environment. It is possible, and this is objectionable. That is why uh, uh, the provision needs to be revisited, and if possible, it should be redrafted. Why? Because uh, other objects, if other objects are directly targeted, and because of that target, because of that damage, environment is damaged collaterally, then that action is not prohibited under this article. This is, I think, for any environmentalist, it is not acceptable. Now, Article 54 of this protocol, uh, additional protocol 1, it prohibits destruction of the objects indispensable to the survival of the civilian population. This is uh, right, that it prohibits the destruction of the objects indispensable to the survival of civilian population. But the same article, I mean, if we read article 54.3, it permits a derogation if the objects are used solely to sustain military personnel or are used in direct support of military action by the enemy. By the enemy. It means that uh, if direct support of military action is alleged, then even the objects which are indispensable uh, for the survival of the civilian population, that those objects can also be attacked. Article 56 of the same additional protocol, it lists three types of installations containing dangerous forces, namely dams, dikes, and nuclear electrical generating stations. Uh, these three dangerous forces cannot be attacked. Okay, obviously it should not be attacked, and this provision is, of course, from the point of view of the protection of environment, and there is no issue with it. Article 56 2A provides that immunity from attack, however, can be lost if these works of installations are used in direct support of military operation. So exception is again here, and this exception says that even such installations like dams, dikes, and nuclear electrical generating stations can also be attacked if they are used in direct support of military operations. Articles 59 and 68 allow the creation of specially protected zone, which could encompass environmentally sensitive areas. So, Article 59 and 68, they allow the creation of specially protected zones. So, in the name of environment, such areas can be identified and they can be declared as protected areas. Now, coming to the Convention on the Prohibition of the Use of Environmental Modification Techniques, 1977. This convention is, in short, known as NMOD. NMOD. Probably the word environmental and modification, they have been used to make uh, an abbreviation for it, and this abbreviation is NMOD. The actual name is the Convention on the Prohibition of the Use of Environmental Modification Techniques. This represents a major advance in the law of war, being the first international agreement which directly addresses the use of environment as a weapon. Use of environment as a weapon. Environment cannot be used as a weapon. I mean, to defeat uh, the enemy or to win a war, uh, the environment of the enemy cannot be exploited in such a manner that it becomes a weapon against the enemy. This is what this convention is all about. Its Article 1 says that each state party to this convention undertakes not to engage in military or other hostile use of environmental modification techniques having widespread, long lasting, or severe effects as a means of destruction, damage, or injury to any other party. Now there is a difference. Here, almost similar expression has been used, but with a difference. We had read in Article 35 where widespread, long lasting, and severe damage was mentioned. Now, these words have been mentioned here also, but in place of and, the word or has been used. And it says that, for your benefit, I'm repeating it. It says that each state party to this convention undertakes not to engage in military or other hostile use of environmental modification techniques having widespread having widespread, long lasting, or severe effects as the means of destruction, damage, or injury to any other state party. Now, here, it is very surprising that almost at the same time, in 1977, uh, the Additional Protocol 1 came into existence. And in the same year, this convention was adopted. Now, why in place of the word and, or has been used here? It seems that in Additional Protocol 1 of Geneva Convention, word as and has been used because there the prohibition is on serious damages. But in case of NMOD, even if the damage is widespread or even or long lasting or severe, then it is prohibited in in this convention. So this convention gives some kind of relief, better relief as compared to the additional protocol 1. So in this way, we find that NMOD under Article 1, uh, the way it has been, the phrase has been used, it is of more use as compared to additional protocol 1 when we talk about the protection of environment, and therefore destruction, damage, or injury to any other state can be prohibited uh, under this clause. Now again, let me again read the provision which I started with and which everybody must keep in mind, and that is the Principle 26 of the Stockholm Declaration, and which was a warning at that time, as a matter of fact, because in those days, uh, we witnessed Cold War between United States of America and the then USSR, and nuclear weapons proliferation was it's on its peak, and the world community was extremely concerned about the existence of this planet and all the beautiful things we have on this planet, including the nature and environment. And that is why in 1972, this expression, the Article 26, has been used that mankind and his environment must be spared the effects of nuclear weapons and all other means of mass destruction. States must strive to reach prompt agreement in the relevant international organ on the elimination and complete destruction of such weapons. Of course, this dream has not been realized even today. Even today, it is I mean, it's a target which needs to be achieved, and the world community hopefully will definitely take action in this regard so that the world may be spared the dangers of such weapons. In 1982, World Charter for Nature was adopted, and it says that nature shall be secured against the degradation caused by warfare or other hostile activities. However, the legal validity of this, General Assembly resolution is doubtful because its prohibition are generally vague and no institutional framework is created to clarify them. Again, if we look at Rio Declaration, uh, two principles are very significant, which are which have persuasive value only. And as students of law, we all know that declarations are not laws. As a matter of fact, they only create soft international law, and through conventions only, we create hard international law. However, declarations are significant because they have a persuasive value. They create an environment and they make us at least morally bound by the decisions taken in those declarations. Just to remind you, uh, uh, even at the cost of repetition, I'm saying it. Principle number 24 says that warfare is inherently destructive of sustainable development. States shall therefore respect international law, providing protection for the environment in times of armed conflict and cooperate in its further development as necessary. Principle 25 says that peace development and environmental protection are interdependent and indivisible. Mind you, peace, development, and environmental protection are interdependent and indivisible. With these words, I end my lecture. And if you want to discuss anything, you're free to now. Thank you.
Thank you so much, sir, for the enlightening lecture. There are some questions asked by the attendees. I would like to go with them. Hamad Jawad has asked that what legal frameworks or international agreements exist to hold warring parties accountable for environmental war crimes and how effective they have been in practice and some related international articles.
Actually, for the violation, two, three things can be done. Uh, Geneva Conventions contemplate three possible modes of enforcement. The first situation is that national courts of states parties may be empowered to try cases of grave breach of rules. I mean, at national level, laws can be created, and those who have violated Geneva Convention or provisions of Geneva Convention, they can be identified and they can be brought to justice. At national level, the countries can do it. One more thing can be done is state party may bring the case before the International Court of Justice or enter into bilateral arrangement to redress the breach. I mean, at international level, we have a very weak, kind of mechanism of enforcement. We do not find a very satisfactory, a system. And there are various reasons. You all know, you have studied international law. Sovereignty is one of the, biggest challenge for it. And unfortunately, we have not been able to create. And the other thing is that gradually we are realizing that the role of United Nations for the last 2-3 decades especially is not very encouraging in this regard. It is unable to create an environment where war can be stopped, or countries can be forced in some way or the other to not uh, engage themselves in international armed conflicts. In this uh, area, we have seen that United Nations role is not very satisfactory because of several reasons. Security Council is unable to function. We have seen Gulf War and very devastating consequences we have witnessed in Iraq, and we are witnessing what is happening in Gaza right now. The international community is almost indifferent, as if nothing is happening. Although in some quarters we are witnessing that people are taking, especially the common people, they are coming out, they are protesting. But as far as this governments of the countries are concerned, they are not curious in taking steps for stopping such incidents. So uh, even I have doubt. Even sorry, there was a call. Somebody was calling me, and uh, there was a break in the meantime. So if you ask me or anybody who is a student of law, who is a student of international law, the situation is not very satisfactory, and we witness violations more and observance very rarely. So I'm still keeping my fingers crossed that someday probably we will achieve a situation, we will reach a situation where better systems will exist, and these issues will be taken care of. So far, we don't have.
So we'll be going with one more question. The attendee has asked that how do modern warfare technologies change the scale and type of environmental damage compared to past wars? And can environmental destruction during war be classified as a violation of international humanitarian law? If yes, under what provisions and what long term ecological impacts remain after conflict ends, especially in soil, water, and biodiversity?
Of course, it is violation. There is no doubt about it. But the way words have been used, I was explaining, widespread, long term, severe, the way these expressions have been used. I mean, after all, if environment is being damaged, the effects are very severe, and in many cases, it is widespread also. But sometimes it may not be. I mean, a long term damage. Even if it is a short term damage, we must have a system where actions can be taken against the warring parties, against the uh, against the country which is violating the international law. Undoubtedly, international humanitarian law has provisions, but my only submission is that these provisions are not without problem. These provisions have problem within themselves, and since international humanitarian law was not created for the protection of environment, their primary focus was not to protect the environment. Their focus was people. their they wanted, I mean, the history of international humanitarian law. International humanitarian law uh, was created to protect the people, the suffering of the humans, to reduce the suffering of the humans only. But in doing so, of late, what we realize that in 1970s, it is around the same time when Stockholm conference had happened. So the world community had suddenly realized that we have to take care of the environment also. So in 1977, we are having a mod also, and we are having additional protocol one. So we have some provisions for the protection of environment in international humanitarian law. One thing can be done: a special convention for the protection of environment needs to be created, needs to be, I mean, adopted and drafted and adopted. So a special care for the protection of environment is the need of the time. As a matter of fact, we are ignoring it. I mean, during wars, the humans are in a position to complain about their sufferings, but environment is speechless. It's a silent sufferer. So all of us realize, all humans, the world community realizes that we cannot, I mean, at least now we cannot ignore and the environmental uh, pollution and the destruction of environment. We must rise up to the occasion, and we must take some step at global level so that new actions are taken, new decisions are taken, and in this direction, a new convention is desired, because international humanitarian law is not sufficient to take care of the environment.
We truly appreciate the illuminating session, sir. Your insights have significantly enhanced our understanding. Now, I would like to call Professor Khalid Shamim, our patron of Virtuosity Legal, to facilitate
Oh my God!
Professor
Oh my
Ahmed this
God!
day.
Oh my God! I did not know that Khalid Bhai is there.
Uh, Khalid, sir, over to you.
Thank you. It has always been a pleasure and honor to have you, sir.
Thank you, sir.
And
Thank you.
and we extend our heartfelt gratitude for your thought-provoking lecture on such an interesting topic, that is environmental consequences of war. Your insight on the devastating impact of conflict on our planet's fragile ecosystem were truly enlightening. Your expertise and passion have inspired us to rethink our role in promoting sustainability and peace. Thank you, sir, for sharing your knowledge and shedding light on this critical issue.
Thank you, sir. Thank you. Thank you.
And if the forum permits me, few informal things may I share with you.
Yes, sir. Please, sir. It will be an honor.
नसीम जो है ये वो हैं जिनको हमेशा मैं ये कहता रहा हूं कि काश ये मेरे सीनियर होते. When I was a student, he was junior to me, but he was such a nice fellow, and apart from this, having that much of knowledge and having clarity on the issues, तो मुझे हमेशा ये लगा कि काश ये मेरे सीनियर होते तो मैं इनसे सीख लेता. लेकिन मेरी बदकिस्मती रही हमेशा कि मैं इनका जूनियर रहा. एंड वन मोर थिंग,
आप मेरे सीनियर रहे सर.
हाँ मैं सीनियर रहा, यही तो
और
मैं कह रहा हूँ, यही तो मेरा
ये
रोना है.
ये
Anyway,
सर आपका बड़पन,
and
जरा नवाजी के लिए
first
शुक्रिया.
encounter on this environmental issue when I was pursuing some refresher course or something. Naseem sir was a speaker over there.
Yes, sir, you had come to Gorakhpur actually at that
Yes,
time.
and with your permission, permit
Sir.
me to quote your
Sir.
sentence.
Sir.
That sentence became something very interesting for me. I started thinking over environment, and it had never been environmental law or environmental science had never been my area of interest. But what he said, when the industrial revolution took place, the slogan was industrialize or perish.
Yes.
And in later stages, slogan changed, industrialized and perish. The
And
same phrase he used when he was comparing principle 25 and 26, where he took that thing, or and. So it has always been a pleasure sharing a platform with you, sir.
Thank you. Pleasure is all mine. Thank you. And thank you, Virtuosity Legal, for giving me this opportunity.
ये आपके बच्चे
Thank you,
हैं,
Khalid.
सरपरस्ती फरमाइएगा.
बिल्कुल. बच्चे बहुत अच्छा कर रहे हैं. इतने सीरियस बच्चे कहाँ मिलते हैं?
तो ये सब तो आप ही के हैं ना.
नहीं, बिल्कुल. जो पूरी दुनिया के बारे में सोच रहे हैं, ये तो बड़ी अच्छी बात है सर. बहुत अच्छी बात है. All the best. All the very best.
Over to you, Nashra.
Thank you so much, sir. It has been an honor for you to be here. And it was actually a very insightful session. We'll love to host you again, inshallah, soon. With this, we can conclude the session.
Yes. Okay. Thank you.
Thank you, sir. Thank you.
Thank you, Khalid bhai.
Thank you, Naseem sir.